and what can be patentable and all things. The next thing comes, how to go about it. So there is intellectual property. India, IPO is a organizations in India. Every country has got own intellectual property organizations. So in that only you have to file the patents. The procedures. There are 3 types of patents: ordinary patent, patent of addition, patent of convention patent. Ordinary patent means most of the patent will apply. Addition means what? You got a patent, you want to improve further, so you can add further component and get another patent called patent of additions. In additional patent of addition, you don't have to show inventive step. You have original patent already show inventive step. Now improvement only you have to show. In that case, you can have another patent, and both patents go together. Together means you have to maintain this patent. You see, once you get a patent, you have to maintain every year for paying to maintain the patents. At the same time, also you have to give a report to them, government, that patent office, workability, how much workability you have used for the patent. If you are not able to use properly, somebody can even ask to give patent that is called compulsory licensing, get licensing from you because you are not using it, it's wasted, so we are going to use it. So with that condition you have to agree. So these are called addition, means you have to improve the patent. Convention means there are several countries form a conventional countries. So there are more than 147 countries are there part of that. Most of the countries are part of that. So you can file patent for all these 147 countries together, or you can choose among them. With same application, you can go for that. You have to pay their fees, but different countries have different fees. But you can start the application from Indian Patent Office for all the 147 countries, or any of the countries where you feel the product is more useful. So there are 3 types of patents used. So you already discussed about that. Patent is legal protection of invention by government for the inventors as an assignee for limited period 20 years, valid within the country of grant. Already this same thing I have shown before. And it is given in Indian Patent Act 1970. And it is exclusive right is that you can make it, you can use it, you can manufacture, you can market it. All the 4 things. You have right to make it, you have right to use it, you have right to manufacture it industrially, or you have to market it. All the 4 rights you have got. And others cannot have all the any of the rights without your consent or with your license, with your assignment. Now you have seen about this. Just a classifications. Pre-search state, before patent requirement, you say subject matter is patentable or not. First check it up all the patentability conditions. If subject matter is not matching, which horticultural or method, or is it a admixture, or is it a some type of combination of the things, or a public morality against, whatever it is, the subject matter should be patentable. Then on second, utility, is one use or not. It's very easy to do it. The second stage, you can see novelty and non-obviousness. For that, you need to refer to patent literatures. Not literary patent, prior art we call. It could be patent literature, could be non-patent literature, could be some public declaration, could be some sample surveys, could be government, websites. All this existing state, you have to check it up and search and compare whether it's novel, new. Novel means what? It's different from others. Non-obvious is not so obvious. These 2 have to meet. And once that is met, then you have to go to application. In application stage, make sure that description is proper and enablement is complete. Anybody can follow that. These 2 has to then. Every details are given. It should be proper enablement. Anybody can use that one. So when all the conditions are met, then we can go for patent. Without that, going for patent is just a it's a formality only. You just get an application and maybe a maximum you get a publication. That's it. If you want that much stay, that's okay. Because for publication and application, nobody sees about the content. But examination means one has to go through that. To get a patent, commercialize it, these are very important. So as the filter, first check it up prior use, prior publication. That is second stage I'm talking now. Prior use and prior publication, you have to check this. I'll see how to do that. And what others are using. Then industrial application ability, you can see they applied on industry or not. Like rat catcher, it can be patentable, provided the method or the equipment you're developing is new. It's not just combining it. It's a different way of approaching that. It's not used so far. It's patentable. Then novelty. then non-obvious or inventiveness. Then section 3, not patentable, it should not be there. And written descriptions, enable description proper, and application and specification should be complete, and claims should cover. Claims should be too narrow. For example, I am doing some studies, 30 degrees centigrade I am putting for 10 minutes in some sodium phosphate solution. Something I have some particular method I'm doing is a new method. Nobody had done that for something. We have done something, at least we did some textile waste treatment using some type of adsorbent. Used this some type Jetropa they used is de-oiled cake and tried to make some type of activated product using sodium phosphoric acid, and use that for treating the textile waste water, and treat it very quickly, and you can immediately within few minutes the colors goes away. Is a patent. You got the patent. So now point is, now if I make claim writing only, so this the procedure, I am declare all the procedures. So procedure is at this temperature, this much time. Then somebody says, okay, 30 degree putting, I'm 31 degree I'll put it. I'm not following your patent. No, I should not be so narrow that everybody can escape. So I cover that. So 30 degree plus and minus. So I give a range, 10 degree to 50 degree, 40 degree. I give a range because less than 10 not possible, more than 40 not possible. Any range will also work. So this way I give a range. Similarly, I put sodium phosphate. So I can do sodium, any alkali phosphate, sodium, potassium phosphate is also applicable for that, or calcium, and magnesium phosphate also applicable for that. So like this, I give a range so that my patent has little expansions. Not complete range. Any type of products cannot write. It should not be too wide, should not be too narrow. So the range should not be others obvious things should not be escaped without infringement. It should be obvious that this is applicable, this must be applicable. Sodium phosphate applicable, potassium phosphate also applicable. So naturally, so if I should write sodium phosphate only in method, alkali phosphates, including sodium, potassium, all of these, I run all the range I can write within this 10% or 80%. This way, the claim should be designed such a way that patent give proper coverage, not too broad a coverage, then not patentable because the process is not disclosed. Too narrow a coverage where everything escapes, the patent has no meaning. So this is the skill it has to be. The claim has to be made because claims are most important part. So after that only this can be filed by patent. When to file the patent application? At the earliest, as you see, the 23 days only that on product the Amazon click, so another company could not get it. They have to pay. So when 1 day delay, we don't know who is filing what time. Otherwise, inventors may apply for patents. If they apply, they may not get patent. If they apply before us, called prior date. I applied now. Somebody applied day before yesterday, or maybe 1 hour before. Then my patent will become prior art. Now his patent was prior art. So my patent is copying that. I didn't copy, but it's already existing. So they'll not be qualified. So that's crucial. It is. So that's why you call that first patent, then publish. Once you publish, they open. So who is the patent documents? Complete specification content, full description of the patent and its operation, how it operates, best method of making the invention, the claims, the most important component of the patent, and determines the legal protection and abstract to technical information. Now, this is a provisional patent. That means what? You have not developed the whole product so far, but you have got already the process, so developing the process. So now you can claim it. Provisional patent you apply. Provisional patent doesn't need much. Only you can write specification of what you discussed, description you write, what is the product, what developing, all finding out. That's much sufficient. Now somebody else working on the field, he cannot allow patent because already you declared that. Now within 1 year time, you have to finish the complete specification, otherwise that will lapse. Provisional specification apply now, within 1 year's time, you have to complete specification how to apply. And so anybody, what the advantage that within this 1 year you can develop the product, and somebody else somebody else in between develop similar things, that will be excluded. They apply for that because already you have already applied for patents. That is the advantage of that. There are different types of procedures available in the patent law. For example, you can have multiple, provisional specification. You can combine together a single specification as a complete, or you can have cognitive. Similarly, you can have complete specification written then find something more improvement, then you declare that provisional. Again, post-date it. Again, rewrite it, complete specification, within 6 months time, 1 year time. That is also applicable. Like some modification there. But idea is provisional means you are still in the process. But you wanted to claim the prior date. Prior date means the date of filing patents. So in that case, you got provisional. But this is not complete, not published, unless you have complete specification. But within 1 year time, you have to complete it. So under patent application, you should have title, invention, what is title of invention, what is field of the invention, what is background of the invention, or prior art, what is existing there, the drawbacks of the prior art, what has not existed, compare the prior art and inventions, how it is different from that, object use, what is the advantage of the things, what is summary of the invention, brief description of drawings, if any, detailed description of inventions, then some examples to explain that, and what are the claims, final, what is the abstract. These are the components of a patent application form called Form 2. But see here, for provisional application, only you don't need claims, you don't need abstract, only description sufficient. Some description about that. Is sufficient just to claim it. Complete specification in case of patent of biological materials you are doing. In that case, what you are supposed to do? You have to mention a biological material. In that case, you have to satisfy both the condition. One, if material not available to public, then application shall be completed by depositing the materials to the international depository authorities. So the two authorities available in Chandigarh, MTCC and MCC, the two microbial culture, microtype culture center. So these places are deposited and get a access number from them. That number you have to put, otherwise they will not accept it. To deposit the materials shall be made not later than the date of filing application. Before filing application, you should have that. Provisional can file before, but final application before that, at least you note it down. There's no know what is the product available. In India, MTech Chandigarh, where Institute of Microbial Technology, you can deposit the materials here and get the action number. The details you have to submit in your application for biological materials. Similarly, if you are taking materials from outside, known materials, but for nature, then biodiversity authority, you have to get a permission agreement from them that we are doing that. So they have to give an agreement for that, so that your product profits 0.2% will go to biodiversity board for maintenance of that. Then claims. Claim is what will protect the boundary of the patents, which others you know what you are claiming, what is the uniqueness of the, or what is the right, and how much protection offered to you. And limits defined based on words and phrasing the claims. This is very important, how to phrase the words and claims. So clarity and completeness and supporting basis are required for that. Then different types of claims are there. One type of claim is independent claim. First type of independent claim. Then depend on that, any additional features for dependent claim. It can product claim, it can process claim, it can apparatus claim, or Jepson claim. So for independent claim I showed here, that does not refer to any other claim. For example, the device which consists of so and so things and which helps for so and so things. So that is the independent claim. That depends on anything else. Now the materials used for that includes rubber, plastic, this, that. That are dependent on the first one. The so and so device, as mentioned in the claim 1, wherein these ingredients used for that are taken from here. That is a dependent claim. So this is a series of claims depend on independent claim or depend on that. Then successively narrowing claims. You can depend on narrowing claims. Independent. Then product, process, and apparatus claim. Claim related to process or product apparatus. The Jepson claim will be something like the process for making widget, where element A, B, and C, wherein the improvement comprise a transitional phase, element D. So something like this, where you combine entire the process of doing something where the 4 elements are there. And each element consists of certain thing. This is a prior art which existed before. This improvement done on that, and this is what you got. So this type of writing called Jepson claim. You find patents. I'll show you how to get the patent applications filled up. So you'll be able to find how they're phrasing based on these 4 categories. Then Marcus claim is very common claims these days. This where you write a list. For example, a claim is claiming how legs may be attached to the table. Marcus claim language. Such claim might be read wherein the fastener selected from a group of consist nails, screws, and bolts. Similarly, the reagents consist of sodium hydroxide, potassium hydroxide, and then calcium hydroxide and magnesium hydroxide. Like this, to give it whole range selected from that. Any combination is also included that. This type of Markov claims. Select from a group of consisting ABC. So these are the different types of languages for writing claims. And now patent agent and attorney. The patent agent or attorney are the person who are authorized to file patent on our behalf, because it involves technical knowledge which already inventors have, and this legal knowledge, including, excluding, and the language should be legal. So for that, so the experts in the field. So patent agents are those who have to qualify patent agent examination. They'll have written examination, they'll have IOS examination, they'll have drafting examination, they'll have thorough examination for that. It is a very tough test. So those who clear this, they'll be authorized by patent agents. So they can file patent for others. Without agent also, one can file a patent. If somebody knows, applicant can themselves file a patent. But usually it's very difficult because they may not know all the rules and regulations, how to applicable everything. That's why patent agents play a role. So they have certain examinations registered in patent office. So they're authorized to do that. Inventor, one who should share inventor should share the complete invention to the patent agents or attorney. And the same manner as a patient has to tell everything to the doctor, other doctor cannot file and treat things. So they have to tell it. Yes, I have to hide certain things. Then you cannot get a patent because enablement is not there. Patent agent will have no right to take over that. They are just processing, ensuring that it meets all the requirements. Patent grant procedures, first to search the prior art, what is existing in this field, but how it stands from that. Then filing application form. Application form involves early publication or after. So what happened there? One publication means what? Once you file application form, after 18 months it will publish automatically. After 18 months. But if you want immediate publication, everybody knows about that. Then you have to, within 1 month's time, you have to pay early publication. For that, you have to pay separately money for early publication. And then after the publications, either ways, you have to go apply examinations, request examination. For that, you have to pay. Again, 2 types examinations. One examination within 48 months you can do. Another examination, expedited examination, which can be first. Again, you have to pay extra money for that. Both examinations you have to pay money to patent office. Then after that, exam. So now when you publish it, it is now open to the gazette. Anybody can see it. So at the time, anybody want to object your findings, or so they can send a opposition to you, pre-grant oppositions, and you have to answer to that, respond to that. And if nobody sends like this, then examiners are going to examine it. They see any pre-grant opposition already available by any other persons, and they themselves examine it. Grant or refusal. Refusal means some condition they'll provide. Why it should not be given. And then comes back to us. Then we have to answer to that. This is called a report, called examination report, first examination report, FER. You have to respond to that. And then if it's granted, then published in the grant of the patent. There is a journal available for grant. So 2 type publication. One is initial publication. After that, the examination, after granting also the publications. Then after that, post grant. After grant also somebody can also oppose post grant oppositions. For that, one board has to be there. So then again you have to answer to that. And finally, the controller decides whether patent will remain with us or not. And these are procedures for that. So documents required for patent filing. The many documents required for that. First of all, we need a covering letter indicating that these 2 documents are filing. Even digital, you don't need that. The digital or you can send that by post or by depositing the office. For us, depending patent locality, depending patent office. Grant of patent form 1 you have to fill up, which is the first application form. There are sections in the patent law. And complete in duplicate with digital, then single is sufficient. The second, provisional specification. This is very important. The specific claim, everything will be written there in form 2. Then Form 3, undertaking in form. So, for example, you are filing patent in any other country, you have to mention that I am filing in other countries also. If you don't file, still Form 3 has to fill up. You are right that not applicable, but it has to fill up. You are right also, if in any other country I am applying, then every 6 months I will inform the patent office what is status. That is Form 3. If you don't have only one India applying, then still Form 3 will fill up, but right there not applicable. Then it is optional. If you want to go to patent attorney, then another form for authorized patent attorney to apply on your behalf. In that case, patent attorney have to fill up everything and submit. Either inform patent attorney. Then final declaration of inventorship. Who are the inventors? This form have to fill up. Please not everybody has to sign. We agree with that. Then certified true copy of the priority documents. In case you have done something, applied some other places, other countries, or then you would say I applied already before in some other countries. So refer to that date will be priority date. Otherwise, application time will be priority. So the priority means before that date will be counted for the original application filing. So it can be before application itself. Usually, if it is applicable in foreign countries or something, other countries applying, it is applicable. Otherwise, mostly priority date will be filing date. Then other required fees, check or DD or digital. So the different forms are available. CC form 1, government fees is 1600 rupees. But usually patent attorney will charge around maybe 5000 rupees, something they charge for just filing. Fees of individual, natural persons, small entities, and education institution are included. Before that, not there. Institute also can go for that. Now, different all other companies they'll say 8000 rupees for filing itself. It's just an official fees, and it has to file. And then form 2, which is main application form, then no fee for that. Form 3, which is techno undertaking, that foreign filing. Form 5, again no fees. It has to fill up only the people are who are inventors. Before complete specification, but after provisional specifications. And form 9, yes, you request for early publication, then you are for form 9. If you just wait for 18 months, automatically published. But if you delay further, so that's in that case the fees required government fee 2500 rupees. And this fees which for the other organization, bigger organizations, 12,500 rupees. For if you are expecting examination first, the expert examination. Normal examination will be 4,000 and 20,000. Expert examination will be 8,000 and 60,000. See, these are very high, bigger companies. And this price is only for, as I mentioned here, it is for online fees. Offline means 10% extra. You are sending by DD, that's 10% extra. The attorney, if signed, then there's fill up. So these are the different forms. The list of all these fees and forms are there. So if you go for this, you'll now I will give a link. Here all the fees and forms are there, but I am not giving details here. So you can have a look on that. There are 31 forms are there for different things. And then timeline. See, within 6 months time, you have to file this proof of application, proof of right for making applications. Somebody claims that I am also part of that. So within 6 months, I have to submit that. So undertaking for filing other country application 6 months. Their rules. So there are details. I am not going details for that, but you can refer to this. So the different time periods given provided for each of the activities, different forms you have to use, and different rules to support that. There are rules and acts or sections. Patent Act will give sections and patent rules are separate. Rules mean it will explain more about act. It give timeline, amount. Rule will give more details. Act will give you the principles. So these two have to be seen, rules and acts. So they are all available in patent websites. So post grant opposition, what is the duration of time, and when you submit, when the opposition board has to submit. So all details are time bound is given. Payment of renewal fee, every year you have to pay renewal fees, and so there are many are there. So you can have a look on that. Please. So they are the patents. We have our patents now. So they have they get certificate like this, where the name of the patentee and name of the inventors will be given, and the title will be given, and it has been granted for so many period of time. Previously it was a bluish color. Now they have changed it. Tri-colored patents. Last year only they introduced this. So renewal fees means every 3 months you have to pay. So 3 to 6 months from the date of recorded registers. When a register is Recording register means after grant. So in 3 months time, within 3 months you give. If 6 months, then you have to pay extra money, late fees. Then further you have to fill up another form for late fees request. First 1-2 years there no fees. After that you have to pay fees every yearly basis. Third to 20th year, because 20 years is applicable. Up to 6 months, due date permissible payment for the fees extension time. After 6 months, if you have not done it, and renewal fee is not paid for 1 year, then it will be lapsed. Again, for restoration lapse, again you have separate application. Okay, so this covers about the procedures for that. Are you all clear about that? What is the procedures? What is the steps? How you go about it? All the forms?
Yes, sir.
Okay. Now the last one and most important. Please tell me any questions.
Sir, I would like to know what is the usual time required from first filing the patent to grant of the patent?
A good question. Actually, it takes we cannot say exact time because it depends upon the process you followed. For example, if you're applying the patent today, then if provisional patent, then within 1 year time you have to submit your complete patent. So that 1 year you are consuming. Okay, after submitting complete patent or complete specification, then if you are waiting for 18 months to publish by itself, in that case 18 months gone. It's nothing done with patent, so that time will be gone. If you want more quickly, then you have to pay extra money for the fast publications within 1 month's time. So then within 1 month's time published. After publication, published only, then you have to pay the examination fees. Examination fees you pay. There are 2 types. One examination fees will be expert examination fees, very fast within 1 month they examine, or there will be normal course they'll take. So normal course will take its own time. You want to make it fast, then you have to pay expert examination fees. In that case, within 1 month the examination comes. After examination report comes, you have to submit it. Then they will take. So they'll give 6 months time open. They'll not grant it because anybody can oppose it. No, you already published. Anybody can oppose your things. I don't know. You don't agree. This is not proper, or these are copied from somewhere else. Anybody can oppose anything. Give opposition. So they give 6 months time. After 6 months time, no opposition. You have already referred examination report properly. They're satisfied. Then within same year itself, you can get grant. Within 9 months time, you can get grant. Otherwise, usually 4 years, 3 years, 3 years to 4 years.
Sir, one more thing. Sir, when we file a patent, does it mean that we have published the work?
It's published in patent journal only, not in a peer reviewed journal publication. So this will not count as the publications.
Will the patent filing be considered as patent publication?
No. Filing will be a receipt only. The receipt will mention that is so patent will be deposited, submitted. That's all. Submission only. You get a SMS in your mobile. That's all. Filing for publication, either you have to pay for early publication, or you can just wait. After 18 months, it will publish automatically. This is considered. Then patent journal will be your patent will available. Your application available. If you wait for 18 months, it will be automatically published. Otherwise, you have to pay money to get it published in 1 month's time. Then only publication. But still, nobody evaluated that. Only after examination, that you have to pay. Examination cannot be paid. In that case, only patent now go to process now. So sooner you do it, faster you get a grant.
Sir, what is the usual cost or charges asked by patent attorneys for filing a patent?
This varies from 35 to 40 lakhs, 50 lakhs. I'm sorry, 50,000 varies.
30.
Some people can go 25, 30, depending upon the person. Pardon?
For the complete process from filing to grant, or just for filing?
No. Filing, they will charge only less amount of money. Maybe maximum 5,000 rupees, because they have to only file it. They don't do anything else. Okay. Because they have digital signature, they can file it. You don't have to go to patent office or anything. You simply send to them, and whatever given, they simply file it. But now, if they're drafting it, they'll charge money, because they have to go details. They have to check this prior art existing or not. They have to give comments. They have to modify claims. They have to make suitable. Okay. For that, they charge minimum 20,000 rupees, and some within 20,000 to 50,000 with that range, 25 to 50 that range. And because they're spending time for each one. They have to keep on contacting you many frequently, finding more details about that. How to put them together. The details not, they'll ask the details. So that procedure they follow because they have to make it stronger. Then examination income, if it is when normal, they're granting it. Then that is very rare. In that case, they don't have to charge any money. You don't have to pay any money to patent office anymore. But if they have to modify questions are that they have to answer it, in that case they charge maybe 6,000 to 8,000 rupees, up to 10,000 rupees they charge for answering the examination report. You may say, what is the guarantee of getting it? There's no guarantee. But just like sending a paper, guarantee of publishing. But chances are high because you meet all the requirements and you will get granted. And by the way, these days it is much easier to get grant than before. Because government encouraging more patent grants. Last year we have exceeded. Previous years we had almost doubled it. So government is encouraging that. So chances of getting grants better.
So you are also a patent attorney. What is your area of specialization?
Actually, you can do any areas. Patent attorneys can do in any areas.
Okay.
So we are doing on patent and for filing from mechanical, chemical, pharmaceutical, biological, every aspects. Because my specialization in environmental science engineering. So actually we cover entire range. Okay. So we are covering all the aspects. It is not something new, but giving a clue to these individual inventors where they can look for. Even before starting the things, also you get an idea. Okay, this is not a patent. Why should I spend my energy for that? I should try to modify that. I should improve on that. So that clarity will be there. The easier to get it. Chances of getting is very high these days because we have filed a patent, everything you are granted. Nothing is lost. Because it's
Thank you, sir.
put properly, it is possible. Okay, now what I request, not just go through patent agents just like that. You do the process yourself. You can take a help, but I expect that all of you should be enabled yourself to do at least most part. Because patent agents cannot help, in general, cannot help on technical part so much. They just have to do the cosmetic work or make it a legal document. But they cannot advise you in your field how details you can go for that. Okay, so in that case, in any case, the inventor's role cannot be taken by anybody else. So it's very important the inventor should have prior art search before itself. You know what exactly looking for, how to look for, he select the things. That only after writing everything, patent agent is going to help you. But that part is very important for inventor to get that clarity. Okay, so this is the last presentation I'm going to show you. How you should start for that. And if you're ready, you can yourself also file. No problem. And in comments, come at that time you can ask patent agent how to answer that. That's possible. So it's not make it commercialize. Start to make it technically more sound, more understanding and applying. That is more satisfying. Instead of just handing out somebody and they can do better justice because they may not know details. And if you are clear, automatically your grant is important. But if you just want application, publication, for that nothing required. You can just send yourself or send to somebody, and just with the 10,000 rupees you'll be published. At least you can show publication. In fact, all the accreditation bodies are accepting publication also. But grant is more important. But there is actually publication to keep. Some institute for PhD also they're taking patent publication sufficient. One patent publication, one journal. So in that case, the publication should be in the name of institute, not individual. Institute may have their own patent agents also. So there are some conditions for that. Is it clear?
Yes, sir. Yes. Okay. Sir, one more thing. So
please.
Can we go for publication in a journal after filing patent?
Sure, definitely. You should do that only. Because otherwise you cannot do it. Opposite is not possible. You publish in a journal and then you cannot patent it. Some condition applicable for within 1 year, possible you have to write a request for grace time 1 year or something. Possible is difficult to do. Better thing, first of all, patent. In fact, it adds strength to your publication. Right now, patent filed. Your number also. The publication is stronger. Okay.
Thank you, sir.
Are you clear? So
yes,
better
sir.
when your product is unique and inventive step is there, then don't publish it. Go for patent first. If it's a normal thing, then you cannot patent anyway. So publication is okay. But inventive steps are involved where unique methods are used. In fact, I'll tell you my experience when I went to patent entrance examination and patent examination, written and written test. There are 2 tests there. One is about multiple choice patent rules, laws and all things, all the different laws, different conditions. Another drafting or draft yourself and so. And then after that, those who qualified both of them, they'll call for the interview. And very first question, the interviewer asked, "Your researcher, you already published so many papers. How many of the papers are actually patentable and you published and wasted it? Can you tell me some of the papers?" I told some of the papers, see, this is what lack of knowledge. I was asked why you wanted to, after this, why you wanted. I told I wanted to do this because I want to help the academic community to develop a knowledge base about patent themselves instead of depending on patent agents so much. I'm not in favor of depending so much patent agents. They can make a marginal help. For that, you don't have to so much use commercial phase. Because that putting say for some amount, small amount you can pay, but you should do yourself. Not that depending on them and simply exploit it. That's not right for procedures. Okay. I would like to help mentoring through patent, not just so much into the patent for you.
So can we get your cell phone number that we can I can be in touch with you?
Sure. The organizers are there and there all have details. We'll have an interaction with that. So I am more interested in patent mentoring than being agent. I can do agent for that, but I wanted you to learn yourself, no? Because why to pay so much money? Yes, we were putting some people because for searching also you have to pay money because searching free search are available, but that's not sufficient. And again, for filing also you have to pay money because you have to purchase that digital signature. So many, and you have to take somebody's help means you have to do some money. Drawing, you are not some drawing required. Then again, you have to depend somebody. Some small amount may be required because we have to do that. And for that, we don't have to charge unduly 50,000 rupees unnecessarily. Not required. So when you do these things, then mentoring that can help you for this type of procedures, which are legal procedures. You can help you what are required for that. I'm not interested in business. I'm a researcher. I'm not in business. I'm interested that you should learn it. That is my whole purpose. Okay. I'll be very happy that you can complete a patent yourself completely. I'll be very, very happy. I'll be successful for that.
So, if you guide me during that process, it will be quite helpful for me.
Not only you, thank you for all the participants. I want that you should file your own patents. We'll help you all the technical things on if required. You can do it, but by and large, you should not spend just expensive money and hand over somebody, and you also not have clarity. You should get a joy of doing that. It's a joy of doing that, like writing paper. You experience that, which others will not experience. For them, it's business only. Okay, we'll go to the last part. Okay.
Yes, sir.
We'll have another session sometimes to have more detailed patent drafting, how to go about that. Maybe some series, maybe 1 week's time. In that case, we'll teach you how exactly go over how to file all the things. But in this session, short session, we cannot cover more than that. Okay, last part I'm covering now is the prior art search and basic drafting. So I'll cover. I quickly go through because time already have exceeding time. So prior art search means all body of knowledge prior to inventions. Can be public use, can be publication. Publication people are using publication, patent, non-patent literature, meeting reports, survey reports, clinical trial informations. But it should not be. There should not be mentioned the samples. Sample can be used. Traditional knowledge or oral disclosure. See, traditional knowledge not in the same country, can be any other country also. Because all the patent is in India or any other country, but traditional knowledge in something in Africa they're using, that you cannot use Indian patent also not allowed. This is on the ground on which the turmeric was banned to patent in America. Because their patent is our knowledge. India we say our knowledge, but their country they're using it. But we stopped it. There is a country that is called WIPO, World Intellectual Property Organization. We applied, this country is a member of that. All the countries are member of this WIPO, all the patent organizations. So WIPO applied and represent the case so that it's throughout the world nobody can use any other country's traditional knowledge. Okay. So then defense publications, defensive publications means what For example, I am doing something, my opponent he may also develop something. So I want to prevent him, so I disclose my things. I may not get patent, but I'll stop him from getting patent. They're called defensive publications. Prosecuting history means what? Well, patent you are writing this, they are giving comments, questions, you are answering the question, again give further question answering, will applying. All these documents also become part of the prior art, which are not known to common people, but are known to the patent organizations. That also not included. Library records may have just a list and catalog. That is also considered patent. I mean, prior art. May not be details, may not be there. Thesis, abandoned applications in internet, Abandoned application means applied patent, but you did not get it, abandoned, or you stopped it. You did not submit the final specification after provisional stopped it, or you have not filed the examination reports. Again, that will lapse after 6 months will lapse. So you've not done that, and or after granting patent you don't pay money. All abandoned. So these also will be included in that prior art. Internet and secret prior art. Secret prior art means what? This is secret to the organization involved, not outsiders. So that also is included. That you may not know it, but somebody can know. Scholarly publication like books, journals, proceedings, reports, industry trade publication, their catalogs, newspaper, websites, everything are prior arts. Okay. So before that, you have to check eligibility, patentability, invention, patentability, novelty, non-obvious, no utility. These two have to be done before doing prior art. Now first the novelty, they see. Novelty means what? Doctrine equivalent. Exactly equal. Same thing we will have done before or not. Because the exam report they'll send you following list of the documents which are exactly matching with yours. That is called identity, almost same. That is not novelty. Inherence means what? Not exactly same, but it is obvious from that. It is just a understanding from that. Inherently it means that. Don't explicitly mention that. Inherency. Enablement means what? It should be applicable. Somebody can apply that, can do it. Enable means it should be workable. Detail, if it is workable, not maintained, or inherently anticipated, or exactly similar, then is no novelty. Any three is valid and no novelty. Non-obvious means what? You have to, there are two objective criteria is the technical advance over the prior art. Technical is advanced. Subjective is that some improvement which is technical advance has two components. One of them is it is improved by efficiency. Second one is improved by cost, lesser cost. Lesser cost means what? Environmentally more friendly, less energy consuming, or it may be more cost, but environment friendly can be one aspect of that. Similarly, different aspects will look for that can make it better than others. Some way or other, not necessarily technically may not be weaker, but it may be better with respect to some other parameters. And second thing is that subjective, that person obvious in the skill, from his point of view, it should not be so obvious. I mean, its experience is not so obvious. Scope and content of prior art. The difference between prior arts and claimed inventions. So what is scope and content, it decides the prior art. Because your scope is what exactly covering and what is the content. Similarly, what is prior art existing and how you are different from them, and what is ordinary skill of the art required by common people, how much they know, and secondary skills, long felt need, unexpected results, they are to be maintained. So inventive steps involves that. Then non-obvious will solve something. You can answer the question: what was the problem which invention addressed, and how long it existed? How long the same problem that people not addressed it? So this also play another role called commercial success argument. These are non-obvious. Obvious for somebody, but it has existed, nobody solved so far. So definitely even similar, but it's acceptable. How significant is the problem? How many people are suffering because of that? How widely it is known for the problem, and how many are seeking to solve it? What other solutions are put forward before the publication of the patent development? To what extent were the factors which would have been taken back in the exploitation of the solution, even if it is not technically so obvious? Technically may not be so obvious. Technically may be so obvious, but still then, without that, to what extent it has been not going on, it's not successful, we're not able to get the help. For example, COVID, you develop something, but it may not be so obvious, but still so many people got prevented by that, so it's patentable. Only thing is shouldn't overcharge it. That's different aspects. How well has the patentee's development been received by the public? Is another one. Public are using, how easy for them to use, how much will it benefited. So these are also taken into account apart from that. So when you're developing something, answer these questions first. Then you will get clarity about that. Once you do have this, then you know how to compile that. Now tell me which patent agents will fill up this question. You only have to answer it. Based on your writing, they do it. So if you already know these things, your writing has become much more stronger. All you know technical skills. Sorry, what do you call that? Legal skills, and we have presented. That's all you need to know. But technical part, nobody can substitute the inventor. So this is where you focus then things will be much more stronger. There's no chance of not getting granted. invention disclosure. How much details need to be put in the application to satisfy disclosure? Visualize the disclosure, how it look like real life. What are the components are there? How are they connected? I process the product. What are other embodiment? What are other alternative available? What are other materials which can be used for that? These are important for writing claims. You may do something. You have to use this concept to expand your claims. What type of coupling can be connected between the components? Coupling can be catalyst, can be mechanical components. How would you like to connect? What other way to improve that? What environmental conditions for preparation usage? Whether change environment would be applicable or not? What a further scope of improvement? Is there something you can change further? When was the first invention in the same field demonstrated, published, and track the present? How much you changed over that? Such compacted keywords from there in the patent, non-patent literature. So written document you have to see, and enablement, how much you can apply it, and how best it can be done. So all the aspects have to be disclosed, and this has to be used for the searching. Utility part at our level in inventive steps. Inventive steps include all the aspects also, commercial aspect also, as I told. And now utility, specific utility address the specific combination environment. For particular combination, specific combination environment applicable. Or credible utility, conceptual knowledge base. It is anybody in the knowledge base know that it's possible. Conceptually, it's okay. Credibility. Just like a perpetual energy machine, not possible. So not credible. Well-established utility, principle and practice in the same domain. You should not violate that. Substantial immunity, ability to cater need of the real world, so that people are able to address that. So all the 4 aspects of utility were included. That means it's very specific combination working out, and knowledge base also supports that. It also doesn't deny over any existing laws and rules and practice in the domains. For example, some civil and mechanical or electrical, you have some standard text, standard books, handbooks. So handbooks concept-wise say that it has to applicable to that standard. Standard is not change it. So it's well established. The factor of safety should be this much, or this weight should be this much, or this size of the column and beam should be varying like this. So these type of concepts are already given there. So how much span required? So you should violate that. That is called established utility. And substance, how many people will get benefited. So this aspect are taken into account into the utility. Now you see, it's not a work. This prior work helps us to develop or fine-tune our idea for patent. Not anything you do patent, after that you go for patent. For beginning itself, we have to frame that way. Then, how to search patent search? Subject per first find out which subject, product or process or system. System is both of them, both product and process. Feature or invention, key components and the structural connectivity. The small component connected, like mechanical, or key steps and sequence, like a process. Or structural and functional components of organization. What is structure, function, are they connected? Any organization. So these are the different features of that. Then based on this topic, which product process and what are the type of features of invention, you divide the keywords and combine the keywords, different combination of keywords. This and this or this and all combined you can do. And search strategy, patent search or non-patent search, both, or selection of database research and field. So there are 4 ways you can search, either field-wise search or from literature-wise, patent, non-patent literature, non-patent literature, and selection database. The relevancy, then how relevant what you find out, how relevant it is to your findings. The relevance should check how closest to invention. That you have to keep it, because not like a paper publication where you write one review paper write almost 120 literature. Patent will not allow that. There are hardly 5-6 reference you can write, or maximum 10, not too many reference, because more number of pages you use, you have to pay more money for that. That is also there, the cost. You pay more number of pages or more number of claims, you have to pay extra money for the patent agents. Patent office. Then analysis, novelty, issue new, non-obvious, and utility. So these are steps you keep in mind for the patent disclosures. Then which problem addressed, check the relevance of the problem or technical status of that. Novelty features, which are searching, each one is say, what is relevance of that compared to yours, how technically it's standing, what is novel feature or combination of the features, what combination of the features works, what is keywords, combination or concept search. Either you search concept like adjectives, like whatever particular type of combustions or generations, or concept you can search, or the keyword you can search. Technical and or commercial, Advantage, what is advantage technically, what is commercial advantage, and what disclosure, how much, what is source of that, what is authenticity, what is date. This information you have to compile for all the literature or searching and prior arts. And then usually the invention proposal they give like this: what is the title of that, what is search method, which method they use for searching, what data they used, what are the findings, what are the comments on that. This is a patent search report. Usually some agents attorney, they'll provide patent search report. You give the details, they'll provide like that. They use their own database for that. Findings, what is patent, what non-patent literature, what is conclusion, what modifications you need to make. Then I refer that there are many. These are three most fundamental type of patent which is commonly available free. Google patent, you can go, you can click that, Google patent open. I'm not doing that, it will take time. Then similarly, the United States patent, you can click there. This here you can find US patents. The Google, and this is the Indian patents. These three are most common patent sources where you can find the patent free. So you can see their findings and your patents. Each category say which patent priorities, patent, the priority patent category, which category it belongs to, which patent office, which patent type, what is patent status, patent language. All the things are mentioned in these patent reports. Some are different languages also there. So what is status of patent? Is it application stage or examination stage or granted stage? What is type of patent? Ordinary or convention or patent of addition? Patent office, which office are patented? Which category process or product? So which patent, priority of the patents? When the priority claimed. So all details should be available in each of the patents. I have compiled 6 patent search links. I have found many, but these 6 I found as most helpful. So for your information, you please try. You don't have time to go through each of them. You click it there, you will find these Indian patent organizations and Indian patent office, where you'll find all the patent available. You can search for your topics. In Google patent, you'll find worldwide escapement. Here you'll find a combination of many patents. This is US patents. This European patents. This US patents. This is another commerce. This also print. This is a patent combination of them. So these 6 sites you search for your materials first. You'll be able to find what other patent literature are available. But patent attorneys, they will have their own paid softwares for doing that. Very much more details, because you may not find many details. But for most common point of this is more than sufficient. Not more, at least it's good enough for your studying research. And patents also have limitation because not published. Many are not published. The time when they started at time is different now. Language may vary. Somebody in different language you can understand. Abstract and title only given sometimes. Public use, some single sell, somebody selling something somewhere, you may not know about that, but they may quote it. Patent examiner may quote it. Country based, not all countries have online database. Some countries may not have. Only 3-4. I told about UK and US. Other countries you may not be so user friendly and not accessible. Most of the countries. Subjective also, type of invention. Every invention there are different types. There are different skill of the searcher who is searching. Their skill is also important. Material being searched. At time also required. For how much time you can give for searching. Can go on. Relevant screen is closest to invention or not. Then final analysis whether novelty is there, non-innovation is there, and utility is there. Your patent compared to all these things. That has to be mentioned. The patent drafting, these are things met. Title, field of invention, prior art, drawbacks, purpose. So these have to fill up in the second form. Title of right, field of invention is field refers to what are the field and related to developing a product for so and so things, developing process for so and so things like this. Prior art, what existed before, only problem, and what is purpose, what is problems with that. Not solution, not here. Solution will be here. Summary statement of the solution. Here, what steps, what are things you are going to accomplish to counteract that? What are the objectives are the 1, 2, 3 objectives? And then summary, how you are satisfying the drawbacks. How is it comparable to that? Then description of drawings. If you have in drawings, drawing 1, describe drawing 2, can be flowchart, can be components of a device, or you flowchart the process. Then, if you have biological material, then you have to go specification, give details about that. When you got it, which location, which time, the details, and if it is something and you have developed yourself, then where you deposit it, that accession number also have to give. Sequence is there, then sequence listing you have to do, then you have to quote that. Detailed description of invention, working of invention with respect to drawings. Then you can detail drawing, if required, you can do. Mechanical is mostly done. Chemical also can, or biological also can do process drawing. Working example, you can explain how it is applicable, what are the methods used for that. Each figure and about a figure number, you get embodiment, you can give any modification possible. Any modification. Advantage of the invention and what is application advantage over the existing ones. Finally, utility. Then claims. Here, most important part, claims not required in the provisional specification, not required. Final specification, not required. Claims. Claim how to frame properly. Then you have to give, if any other drawings apart from that, you have to give the drawings. Here the description of the drawings, here detailed drawings. Here, then abstract invention within 150 words. Write very abstract within summarize. Summarize includes everything. What are the previous problems? What improvement you made? What method do? What is the objective? What are the major claims? You can online and physically, you can either ways. Okay. Now this is presentation over. You have any questions on that or any of this? Did you get an idea what are the things to look for drafting, searching and drafting? Any questions? Anybody? Is it clear to most of you? And at a short time, I'm covering a lot of areas. That's why I give a recording so that you can at least go through once again, get in clarity. But I think I covered all the essential aspects of the patent, what it is, what is steps of that, how to search, what are the criteria, and how to apply for that, how to go for your search. Is it okay? Anything else you want to say? Any of you?
Sir, what are the basic criteria for becoming applicant for the filing the patents?
Okay, nothing required for patent examination. Every year they organize one examination. For that, you have to go through the patent rules and laws thoroughly. You have to know exactly which rule is what, which law is what. It's a very good scope now because a lot of patents require your specialization matches with that. A lot of scopes are there. So for that, you have to clear each paper more than 60% marks. Actually, 50% marks, but total will be more than 60% because 100 marks will come from multiple choice where they get case study they'll provide, or rules provide, laws provide, which law says that, how it is applicable or not. Like this, some question comes for clarity, understanding, and concept. Second paper will be a drafting. You have to write a full draft. Here is there is some content, you have to draft yourself. You write your own claims and some conditions applicable, how you go to FER. So this way they ask the drafting. Once both papers are clear, then go interview. And all the paper together, you should get 150 marks. I mean, out of 300 marks. 150, 60% marks you have to get. So to clear that. So in every year, probably around 70, 80 people, no, maybe 100 people clear it. So far, actually, 1970 onwards started. So far, you will not find more than 300 to 400 patent agents all over India. So in particular state, maybe hardly 10, 15 will be there. That will major cities. So it is a good scope is there. But it needs a thorough studies. So if you want anybody of you want to apply for patent agents, I can help you for preparing for that. So that is a separate issue. We can go for that. So how to prepare, how to go for that, how to, what a question may come, what a previous question paper also available. So okay, any other question? If not there, I will go to the patent website and show you because it is a workshop. So far conceptual that I have not started workshop part. Can I go to, if I don't have any questions, can I go to patent website and show you?
Yes, sir.
Okay. So now hope it's not getting too delayed for you. It's not too slow for me. Okay, so you can go ipindia.gov.in. Simply type Indian Patent Office, then automatically it will come. You simply type Indian Patent Office. Automatically, very fast itself will be Indian Patent Office. You click that ipindia.gov.in. See this website.